Here are your Court News Ohio top stories in 5 minutes. A death row inmate challenged the second execution attempt to the Ohio Supreme Court justices on June 9th. The state tried to execute Romel Broom in 2009, but was unsuccessful. Medical staff was unable to insert IV lines, which allows them to inject the lethal drugs into Broom. After 2 hours of trying to insert the IVs, the governor stopped the execution at the request of prison officials. Broom was sentenced to death for the 1985 kidnapping, rape, and murder of a 14-year-old Cleveland girl. Broom's attorney argued that a second execution attempt would constitute cruel and unusual punishment. She also wants the justices to determine if Broom is being punished twice for the same crime, or double jeopardy.
Putting Romel Broom through another execution, regardless of the character of it, would be a cruel and unusual punishment.
And double jeopardy.
And double jeopardy.
And so in order to find double jeopardy, we need to find that the preparation that was done with the insertion of the needles in the catheter was in fact a protocol that was far enough along to be characterized as an attempted execution.
You could argue that the attempt begins with the reading of the death warrant, but we have taken the position that at the very latest, when the instruments of death, those needles that are essential to carrying out the execution, pierce the inmate's skin, there must have been an attempt.
Broom's attorney cited a 1947 U.S. Supreme Court case that states death by installments is not allowed. She also claims that the state violated several protocols for an execution at the time, including a third required exam of Broom's veins and bringing in an outside doctor during the execution process. The state claims that a second execution attempt isn't cruel or unusual when equipment failure prevented the first execution. The state also argued that Broom's execution never really began because no lethal drugs were injected into his body.
The difference between attempting to start an intravenous injection in someone and actually administering a lethal drug to that person is paramount.
Look for a decision on this case at sc.ohio.gov.
In a second death penalty case, the Ohio Supreme Court justices on June 10th heard arguments about whether a Cincinnati man's death sentence should be overturned for a second time. Rayshawn Johnson, who in 1997 was convicted of murder, asked the justices to give him a third penalty phase hearing because he said potential jurors at his second trial were removed by the prosecutor because of race and that some evidence should not have been admitted. Johnson asked the Supreme Court to set aside the death sentence and order a third trial.
They should have referenced Millerell versus Drecke because that specifically says if a black juror is removed for the same reason a white juror should have been removed, and they're not removed, that shows purposeful discrimination.
So the justices affirmed his first death sentence in 2000, but a federal court overturned that decision on appeal.
The Ohio Supreme Court disbarred a Cleveland attorney for practicing law while he was suspended. The justices indefinitely suspended Sean Brown in October 2011 for misconduct, but investigations showed that he continued to represent clients and appear in court on multiple occasions. Brown was originally suspended in 2011 because he neglected cases for 3 different clients. On June 17th, the justices permanently prohibited Brown from practicing law again in the state.
Chief Justice Maureen O'Connor spoke to members of the 2015 Ohio State Bar Association Leadership Academy this month and said they should lead by example through listening and with honesty. The academy consists of young lawyers training for future leadership opportunities in their bar associations, professions, and communities. The 7-month training program that started in January covers sessions on ethics and professionalism and community service, among other topics, with the goal that participants will become effective leaders. The group will graduate in mid-July.
The summer kickoff to the 2015 Law and Leadership Institute started in June. Nearly 400 new and returning high school students from across Ohio are attending LLI orientation sessions throughout the next 2 weeks. LLI is a 4-year academic program that collaborates with the state's legal community to prepare students from underserved communities for college and professional success. Earlier this month, instructors and staff working with the students participated in a training conference where they learned about LLI's curriculum and how to better introduce high school students to the law and legal profession. Classes for the high school students begin on June 29th. That's a look at Court News Ohio's top stories. Visit courtnewsohio.gov for the latest headlines on Ohio's courts. You can also follow us on Facebook and Twitter.